Hello and welcome to another episode of A Question of Law. The show is interactive and we want to hear from you every time throughout the show. Use the hashtag A Question of Law, and WhatsApp line is 0550585832. Of course, this is CTTV's legal education program, and we basically look to try and break down the law as it pertains to our daily activities in life. Don't go anywhere. We'll take a short break. We'll be right back to continue the show. Welcome back. Now, my guests are seated. I have with me a senior law lecturer at the Faculty of Law at GIMPA and also a private legal practitioner, Clement Kojo-Akapam, and also Salam Adono, who is also a private legal practitioner. Hello, gentlemen. Welcome.
Thank you.
Yeah. So we were speaking not too long ago about, the need for an EI, to be issued by the president for the sake of mandating vaccines and all of that, mandating the taking of vaccinations and all of that. We haven't seen an EI yet, but it seems as though some level of instruction have gone out for people to take, the vaccines as a mandatory thing. And then some people are also agitating and saying, listen, you can't do that. Where's the EI?
So, no, I mean, as you can see today, we are in our marks. We are
in compliance.
In compliance
with the EI.
The point, Kweku, is that what we said here the last time is if you want to restrict the rights of others, you must do that within a certain legal framework.
Yes.
And the known and prescribed legal framework to do this is on the back of an executive instrument pursuant to an act. So if it is pursuant to the Imposition of Restrictions Act, our expectation is that we'll see an executive instrument.
Yeah.
We also pointed out on the program that the Public Health Act also gives room for such compulsory vaccinations.
Okay.
But also that must be done by the minister if he so wishes, that is the Minister of Health, to go through the procedure of issuing an executive instrument. Now the point here is whether or not expressly this issue of a vaccine mandate has been issued.
Okay.
What we know from the publication is for persons entering into the country and exiting.
Yes.
And it has become a requirement of travel. So I think that we are in a very interesting gray area where now we are not applying the vaccine mandate for use to access public areas or as a condition for employment in the public service. There's been rumors that very soon it will become a requirement for employment.
Yeah.
It will become a requirement for having access to certain public places and public buildings.
Yeah.
But has that happened? I don't think that has happened yet.
Okay.
We think, and I still hold the view that for that to happen at that level, we will require an executive instrument, but as a condition of travel, based on the rules of travel, you can place restrictions on who enters your country and what conditions the person must meet before entering your country, including visa requirements, health requirements, and even having satisfied some financial requirements before you can enter into someone's jurisdiction. So for the purposes of the entry and exit at the airport, I think that we are within a certain gray area, and within the current happenings, which is a global pandemic, we can seek to regulate how people enter the country and they exit.
Okay.
So that's my view. But if we want to go ahead with the vaccine mandate, clearly we will need an executive instrument.
Let me, I'm sure Solomon has something to say about this, but let me just quickly read a portion of this article that we have here, published on the 20th of December on citynewsroom.com. It says that as part, so the National Communications Officer of the National Democratic Congress, NDC, Sami Jemfi, and 3 other persons have sued the Attorney General and the Ghana Health Service over government's mandatory COVID-19 vaccination policy. As part of efforts to get more Ghanaians to vaccinate against COVID-19, government has introduced new measures at the Kotoka International Airport. Okay, which is what you talked about just now. It has also announced plans to prevent the unvaccinated population from accessing certain public spaces such as stadia and entertainment event centers during the Yuletide. Okay, so this is where I think we've stepped into that space where it's now dealing not necessarily with travel alone, but also with internal movement within the Ghanaian space. So, I mean, this is where we find ourselves.
Yes, very interesting. We did state on this program some time back that you necessarily need an EI to do a lot of those things which have become known as vaccine mandates. Vaccine mandates, as we've seen in some countries, it's not blanket. I mean, it's not just across. I mean, typical example is in the US, for example. I've not seen or read anywhere that says that there's a mandate for every single person across the United States, for example. So
I think what I saw was federal.
Yeah, so the federal government, for example, the government of the US, a mandate signed by Biden, made it mandatory for all federal employees. That is to say, public sector employees or federal employees. You know, it's a federal system. So all persons connected to the federal system as employees will have to be vaccinated before they can do things. So that's one. In New York, for example, so that's one. In New York, what they did was to make vaccination mandatory for health sector workers or workers in the health space. So for those people, it is mandatory. And a few other places like that. So there are specific groups of people that the system feels it's important for them to be mandatorily vaccinated. Apart from that, I've not quite seen, an across the board, blanket mandate for everybody to be vaccinated, at least in the US. So that is fine. So they all approach it in a piecemeal fashion. So what we have seen in Ghana is, I don't know how to call it a vaccine mandate yet, but a directive from the airport company, surely with the assistance or the concurrence of the Ghana Health Service, to make vaccination mandatory for people leaving the country and Ghanaians returning or persons returning who have not vaccinated. I don't know whether to call that a form of vaccine mandate or not, but that once it makes it compulsory, and in the framework of the definition, I think we can say it's a form of mandate. And so the question then arises whether that is an infringement on the rights of persons or not. So, like you rightly pointed out, the Sami Jemfi, who is the national communication officer of the NDC, though he has said that he is doing this on his personal accord and not connected to the party. He's just doing this as a lawyer and as a citizen of Ghana. He obviously has gone to court together with three or so others to vindicate their rights in respect of the fact that they say that the requirements for imposing such a mandate have not been followed. And as far as that is concerned, that is an infringement of the right. Like Clement rightly said, once you want to do a thing like that, you must play within the legal framework. And so that legal framework, in their view, has not been set. And so anything done in pursuance of the directive from the Ghana Airport Company or the Kotoka International Airport becomes, a violation of their rights. I have the declarations they are seeking just before me. They have 8 declarations in all, just to take a few of them so we can dilate on that. So first, they are seeking a declaration that the impugned directives, by impugned directives, they mean the directive from the airport company, a declaration that the impugned directives of the respondents are the Attorney General and all those people, specifically Attorney General, the Ghana Health Service, and the Ghana Airport Company. These are the respondents. A declaration that the impugned directives of the respondents breach or threaten to breach the applicant's fundamental rights or human rights as enshrined under Article 21(1)(g) of the 1992 Constitution. So what does Article 21(1)(g) say? Article 21(1)(g) is that provision on the freedom of movement.
Yep.
So it says that freedom of movement, which means the right to move freely in Ghana, the right to leave and to enter Ghana, and immunity from expulsion from Ghana. So that is the right they are claiming is being violated. So that's an important thing to note.
Okay.
So that's the first relief they are seeking. Second, the second relief is a declaration that the impugned directives of the respondents violated Section 2.1 of the Imposition of Restrictions Act 2020. That's Act 1012, and Sections 21, 22, and 30 of the Public Health Act 2012, Act 851, and therefore is illegal. What does Section 2.1 of the Imposition of Restrictions Act say? The Imposition of Restrictions Act is that act which was passed in the heat of the COVID that allowed for certain restrictions to be imposed. So Section 2, Imposition of Restrictions. 1, it says that the President may, acting in accordance with the advice of the relevant person or body, by executive instrument, impose restrictions specified in paragraphs C, D, and E of Clause 4 of Article 21 of the Constitution. So what they're trying to say is that this has been violated because there has been no EI issued to impose the said restrictions.
Yeah.
So that is the second point they are making. And they also mentioned the Public Health Act, Sections 21, 22, 30. Those parts essentially deal with compulsory vaccination, etc. And the fact that in this case, not the president, but the minister should be able to issue an EI for the purposes of compulsory vaccination. The point they are seeking to make is that EI has not been issued, so the directive lacks legal backing. And as far as it's a matter of their fundamental human rights, a directive is not competent to violate their fundamental human rights. A prescribed format must be used to take away that rights from them. C or 3 says a declaration that the impugned directives of the respondents contravene the guidelines of the Food and Drugs Authority on the administration of emergency use, authorized medical products, etc. They also go ahead to say a declaration that the impugned directives of the respondents contravene the guidelines of the WHO regarding proof of COVID-19 vaccination for international travelers, and that same is unreasonable. A declaration that the impugned directives of the respondents contravene medical ethics and best practices that govern COVID-19 vaccine administration. Another of certiorari to bring before this honorable court the impugned directives of the respondents to be quashed as having been made without any constitutional or legal and or reasonable basis whatsoever. They are also seeking an order of prohibition and or injunction directed at the respondents, their agents, and or assigns, restraining them jointly or severally from taking any steps contained in the impugned directives relating to the implementation of compulsory COVID-19 vaccination at the Kotoka International Airport, constituting restrictions on the freedom of entry into Ghana of citizens and the freedom of leaving Ghana of all persons. So essentially all they are saying is what we've also said here in the past few weeks, that you essentially need a certain legal instrument, EI in this case, to enable you impose these restrictions. So that's what they are saying. There's an argument to be made for and against the issue of traveling. We made a point here the last time about yellow fever, etc. I'm not sure whether, because yellow fever has been around for a long time. I'm not sure what the legal regime was at the time before that was introduced. I'm not sure, maybe I need to find out. But the point they are seeking to make is that once this particular restriction takes away the fundamental human rights of movement and restricts even Ghanaians from traveling outside and even citizens of Ghana from traveling inside, that they think is a violation of their fundamental rights on movement as guaranteed by the Constitution. And necessarily we need an EI to enable the airport company, for example, be able to implement the directives itself. So the directive on its own is not enough to take away that right from them. That I think is the argument they have, and that is the reliefs they are seeking from the court. It's interesting because I personally was waiting to hear something in this respect from the president when he did his last
actually was
update,
as well.
yes, but he maybe for good reason did not say anything about that. He only emphasized the protocols, etc., and said a few other things. And the main restrictions, as it were, we are told will begin in January.
Yeah.
Hopefully, the president will do what is right by that time, so that we can have some clarity on the way forward, etc. So as it stands now, it is tricky. What can Ghana do in respect of its citizens outside who want to return to Ghana?
Yeah.
Can they be compulsorily vaccinated, that is against their will, when they get to the airport without the EI? So I think that is, and if you were a foreigner getting into Ghana, the discussion is different. But you are a citizen of Ghana from a different country entering Ghana. You've maybe tested negative, etc., done all the things you have to do, which is allowed, which other laws allow for. But you are not vaccinated. Can they compulsorily vaccinate you in the airport? I think that is where the grey area is. That's what we are seeking to address.
Yeah. So, I mean, I think that clearly on this issue, what will happen, and I'm hoping that in January, if we're going to have a full-scale implementation of the directive, there will be a certain legal framework. But, that legal framework does not even stop anyone from going to court, because if you look at the Constitution in Article 33, where you can go to court to enforce your fundamental human rights, says where a person alleges that the provision of this Constitution on the fundamental human rights and freedoms has been or is being or is likely to be contravened. So you can go to court. You cannot say that, we've not implemented it yet, so why are you in court? Because under 33, it's either it has been infringed upon.
It enables you to, or it helps you to anticipate.
Anticipate. So we are hoping that. So my point is, if an EI is issued, then this matter becomes dead, because then there will be no issue. Because
the return date on the process is 18 months.
Well, I mean, I'm just looking at this article, a different article which was written earlier. The Minister of Health, Kukua Jimamenu, says government will from January 2022 inspect COVID-19 vaccination cards of specific groups of persons in the country, including commercial drivers. So I mean, like Salam said, I mean, I'm hoping that early in the year.
So there's a scope, because he's saying including, so that I will be surprised if we want to do a full-scale rollout of this issue and we don't do it.
But if they don't, so what happens to the issue about going to public places like restaurants, stadia, etc.? So without the blanket one, it will be difficult to enforce that, unless of course you tell yourself, I will not vaccinate because I'm not going to a restaurant, I'm not going to stadium.
Now you do take out, you order for delivery.
So then that takes you out. But as far as you want to visit any of these places, then you will have to get vaccinated.
Right.
And that's what the EI should specify. The EI should specify even age groups. The caliber of people. Can pregnant women take it? We don't know. Can nursing mothers take it? The exemptions, which people should do it. And that should bring clarity, so we are on the same page. Like it did in the previous one, where
the lockdown, for example,
it exempted certain groups of people, journalists, health workers, etc., were exempted from
lecturers were not exempted.
The restrictions.
So we had to stay home. And nurses, media men were exempted.
But well, I mean, you could have gone under a different, or you couldn't.
Me, I'm afraid of. I comply.
So it even served you well.
All right, we'll take a short break. Don't go anywhere. A question of law will continue. Come back. Now, the never-ending issue of deputy speakers of parliament. Are they speakers? Are they not speakers? At what time are they speakers? Do they lose their vote? Do they not lose their vote? All those things. Well, let's just delve into the conversation right now. Gentlemen, when is this thing going to be put to rest? Finally.
No, I think we will need some clarity in legislation to put this matter to rest.
Okay.
The reason why I say we will need some clarity in legislation to put this matter to rest is because if you look at the various interpretations, the comparisons with other provisions, there are clearly two schools of thought.
Okay.
One school that believes that there is the office of the speaker, which includes the deputy speaker, and the other school that says that the office of the speaker is different from the office of the deputy speaker. I think by now you know the school I belong to. I think that these two offices are not the same. The office of the deputy speaker, in my respected view, is not subservient to the office of the speaker.
Okay.
And I say that because if you look again to our constitution, there are clear pathways of becoming a speaker and becoming a deputy speaker.
Okay.
For that reason, those two offices cannot be said to be the same.
Okay.
And I repeated this the last time here.
Yeah.
They might perform similar functions,
yeah,
but they are not the same.
Okay.
Now, there's been comparison between the speaker, deputy speaker, and president, vice president. Clearly, if you look at our constitutional architecture, the vice president is that office is subservient to that of the president.
Yes.
It's clear.
Yes.
There's no debate about that. If you look at our constitutional architecture, particularly if you look at Article 60, sub 8, it says, whenever the president is absent from Ghana, for any reason, the vice president shall perform the functions of the president. And this is the important part. It says, the vice president shall, before commencing to perform the functions of the president under clause 6 of this article, take and subscribe to the oath set forth in the second schedule. Meaning that the vice president takes an oath which is lower than the oath that the president has taken.
Okay.
Similarly, if the speaker is to act, and in the matter of Atta Mensah and others versus Attorney General, if the speaker is to take the seat as president in the absence of president and vice president, the speaker is also expected to subscribe to the presidential oath. Now let's come to the office of the speaker and deputy speaker. The deputy speaker and the speaker will all subscribe to oaths. And if you look at our constitution on oath, clearly there is the speaker's oath. And both of them will subscribe to this oath, the speaker's oath. So that's why you will not need the deputy speaker to subscribe to another oath before.
Separately,
Kweku, the point I'm making is that the speaker has a constitutional function. That sole constitutional function in relation to parliament is to preside over parliamentary proceedings. Now, we have, through an act of parliament, created the parliamentary service. And in the parliamentary service, the speaker now is the chair of the parliamentary service board. So he has other administrative or legislative functions he will perform, which are not constitutional functions. Now, if you come to the deputy speaker, it is my view that the deputy speaker has only one role to play, a singular role ascribed to the deputy speaker by the constitution.
Interesting.
And that singular role to be performed by the deputy speaker is to preside in the absence of the speaker. It means that the only constitutional function giving a deputy speaker is to preside when the speaker is absent. It doesn't say he is acting when the speaker is absent. Because, Kweku, strictly speaking, in law, when you say someone is acting, it means that the person is meant to hold the fort until something, but he's not acting. That's his role. He's not acting. He's not in an acting capacity, hoping to be confirmed in future. That's not what is happening.
He's actually a speaker.
He's actually performing his constitutional duty of presiding.
Okay.
Now, we've made the argument of privileges and that he has other privileges. All those privileges come because of the fact that he will be able to preside in the absence of the speaker.
Okay.
Clearly, our constitution says the speaker has no casting nor original vote. The constitution is clear on that. The reason is out there. The speaker of parliament is not a member of parliament, so he cannot have a vote.
Yeah.
Now, if we agree that a deputy speaker, when not presiding, can have a vote, then we can also agree that the speaker and the deputy speaker are not the same. Because whether presiding or not presiding, the speaker does not have a vote. The only time that the speaker might have a vote is when he's performing his functions under the Parliamentary Services Board, where he chairs. But where he's presiding in Parliament, performing that role in the Legislative Assembly, he will not have any vote. So if we agree to that, now what happened recently on the issue of whether while presiding, you can de-preside and go and vote and then unpreside.
Re-preside.
The point is, it looks like an interesting constitutional game or analysis, but I think that clearly, once you are presiding over an activity. Now, specifically to what happened, you were presiding over a division vote.
Okay.
So once the division vote has started, you have lost whatever rights you had to join that because you were presiding.
Okay.
You understand?
Yes.
So you cannot say that, oh, I was presiding in the middle of a debate. That's different.
Yeah.
And then, because of reasons, I excused myself. Another person took the seat. So I came back and I joined the debate in the chamber. That to me is different. But if you are presiding over a specific event, like a division of a vote, that exercise has started. So whether you can vote or not, at the time you said it should start,
it's too late. You can't join them.
So anymore. I think that we need to clear this up. The reason why we need to clear this up is that the Constitution does not take away. The confusion we are having here is not a confusion created by the Constitution. It's a confusion created by the standing orders of Parliament, where the standing orders of Parliament will define the Speaker to include a Deputy Speaker. So the problem is not a creature of the Constitution.
Okay.
And that's why I say that if we go back and look at our constitutional history, yes, there's been instances where we have stated clearly in our 1957 Constitution that the Deputy Speaker has an original vote. It's stated clearly in there.
Okay.
So if the standing orders now defines Deputy Speaker as Speaker, then it means that all the rights, all the privileges, all the limitations of the Speaker applies to him. But the standing orders is lower than the Constitution. So we need to look at how to correct that. And I say that we should come out clearly with the duties of the Deputy Speaker, the rights of the Deputy Speaker, the clear functions of the Deputy Speaker. That's the only way we can use, we can solve this current problem. Otherwise, it's going to happen. And we saw clearly, because it's the question of numbers.
It is.
Because if it's going to reduce my strength to enable me to take a decision, then we will go into these mechanics of trying to interpret the Constitution to suit a certain end. So yes, I think that we need to solve this going forward.
Well, we do, yes.
Yeah, so like Clement rightly pointed out, the standing orders define Speaker or Mr. Speaker to include a member presiding at a meeting. A member simply because in the absence of the Speaker and Deputy Speakers, any member of Parliament could be made to preside. So at the time, even an ordinary member of Parliament is presiding, the standing orders contemplate, or the standing orders view that as Mr. Speaker because he's the one presiding. Yes, there needs to be some clarity on that, so we make progress. On the event of the recent event where the two deputy speakers were exchanging roles, whether it was for Joe Osei-Wusu to go and vote or whatever, quite interesting. Of course, the majority leader came with an explanation that he was not, getting up or leaving the chair to go and vote. I thought that was an afterthought because it had been hinted earlier that, that possibility existed. So I thought clearly it was an afterthought. So that is it. But let's look at it from the popular or obvious thing a lot of people thought he was going to do. He was going to vote. People thought so. But could he really have gone to vote? Because he was presiding over the vote, which became a division, which is a form of a vote.
Yeah.
And so it was a voice vote. How would he have voted? Because he did not take part in the voice vote. So he couldn't have, said he was going to vote because he was not going to validate his voice vote because he did not vote.
Yeah. So I find it curious because it seems as though the members of parliament, probably the backbenchers, maybe don't even understand this particular clarification that you've just made. Otherwise, there was no need for the agitation we saw.
Yes, because
if he gets up, right, on what basis do you say he's going to vote? Because it's a voice vote, isn't
and
it?
He did not take part in the voice, as far as we saw.
Yeah.
And we would have heard him because he has the microphone is louder.
Yeah.
So he did not vote, and that would have been unconstitutional because he was presiding. So he did not take part in that vote. So I don't know what he was thinking, and I don't know what the backbenchers.
And in the voice vote, numbers don't matter, do they?
Yes, numbers don't matter. So volume. It's when you are not clear or you contest the decision of the speaker in respect of his pronouncement of the voice vote that the standing orders allow you to call for a division. And so a division will be a validation of the voice vote. So that's what was happening. So they were counting them, calling them one by one to count. So the deputy speaker could not have claimed or said he was going to vote or to be counted. It would have been interesting if he did, because he was not part of the original vote that was being validated by the voice vote. Well, the backbenchers must be educated to know this. However, perhaps given what had happened earlier and how sometimes we see our parliament, people pushing things through every now and then, maybe they fear that even though this exists, it could pass and becomes an illegality, but the act or, the matter under consideration would have been decided. And once they use that approach to decide it, the bigger one, which was the passing of the bill itself, would have also used a similar means to do. I think we are all learning. I think they are also learning. And now that we know that, at least from the majority leader, he was not going to vote, he was going to take his medicine or attend the bathroom. Well, let's see how it happens. Next time they are resuming on the 18th January. Maybe speaker will be around, maybe not, or any time speaker is not around. Let's see how this works.
Is there time to look at the constitution and say that we will need only one deputy speaker who is not a member of parliament? Because the numbers, and if you look at historically the numbers, the number of smaller parties and independent candidates who used to make up the buffer, it's been reducing. And this currently in this parliament is zero with one independent candidate. It would actually have been none if that independent candidate had contested on the ticket he had wanted to contest initially. So we need to now start thinking seriously about, because it's going to happen. If the numbers are this close and I give up one of my members to the office of deputy, how does that? And I think that in the constitutional architecture and thinking, it says that two deputy speakers not from the same party. So hoping that both of us would lose, but it doesn't. We still become even, because if I lose one and you lose one, we're still even. So I think that
it would have been interesting, Clement, if the two deputies were from maybe NDC and MP, maybe first deputy from MPP, second deputy from NDC. It would have been interesting, because once the speaker was not around, the other one will call and say, no, I can't make it right now. So you just start. When I come, we will see. So just when the vote is about to start, you sneak in. So I just arrived and you are presiding, so go ahead and preside. so the numbers are interesting. We surely must do something about it. I don't know how. I don't know whether it will have to do.
Then, of
with
course, there's also the
creation.
case that is going to the Supreme Court,
Which is Sky's case.
Yeah, which is Sky's case.
Yeah, I mean, the Supreme Court is the best way to get
finality
to this. Also, Parliament can use its own processes to bring clarity to this, even at the level of the standing orders as started.
Well, so Parliament can do that, but I don't know how that process will be because, of course, when they are seeking to bring clarity to that using the standing orders, etc. Fortunately, they are
the same numbers,
and they are considering. Amending the standing order. It's been on the books for a while now, and I hope Speaker Babin, being in Parliament for a long time, will now push this particular issue. But now, if they want to do anything in respect of the numbers, both sides will have the current situation in mind, and it will be one of the acrimonious debates or considerations ever, because everybody, even though it's for the future too, they'll be looking at the present and see how the standing orders as being couched now will help or should I say, go against a particular party. It will be interesting, but in the end, we should have some clarity.
Why don't we just do a couple of minutes of a quick throwback to some of the stories that we touched on earlier. The Takoradi woman's case. I think it's still in court.
Yes, it's still in court. Yes, it's still in court. Only that I think the media attention on the case is waned.
Dwindled.
Yes, I think it's waned.
Now, as usual, the fanfare is gone. Yes. I mean, linked to that Takoradi story, my biggest will be, since we are still in December, will be religion and the law and prophecy.
Okay, religion, law, and prophecy.
Yes.
Okay.
You remember
the
issue of prophecy.
Of prophecy, yes.
And whether or not you can put someone in eminent fear by a certain prophecy. We looked at Nathan and David.
Yes.
That's my biggest moment, because this is the season for such prophecies.
Interesting. I want to see what happens on the 31st this time around. If you recall, was it the 10th of last year into this year that Owusu made a prophecy about the chief imam?
Right. Yes.
Was it this?
It was this
year?
particular one. Yes.
And the young people in the Muslim community got angry and stormed his church, destroyed a few things. He later had to go there to pacify the eminent chief imam. I think he might have learned lessons from that as well. And given what has happened to him himself in these times, I mean, it will be interesting to see the kinds of prophecies that people will come up with on the 31st.
Not even about the kind, but the way you go about it.
The way it's done.
Because I'm sure that the telephone line to heaven is active by now, and the calls are coming through. So they are writing down. As you said, you are they write it down.
They write it down and actually read those down. It will be interesting what they will also have to say about the current happenings in Parliament. I'm sure one or two of them will see a few things about the current happenings in Parliament and what the future holds. But I think my biggest, two, the election petition is one. The election petition and how different this was from the previous one in terms of this attacking the declaration proper and how it turned out and the new changes that particular election petition is brought to courtroom processes in terms of witness statements and when you can object to witness statements, etc., and what that means even for case management. I think that is a big one. Now these days, if you're doing case management, you'll be asked whether you have any problem with the witness statement. The judge will quickly add that even if you did,
this is not the time.
He's unable to help you because you have to attack it when it's being tendered. The second one will be the LGBT debate and all the things that came around.
On that was number 2 for me.
Okay, so the LGBT debate, I think the tempers have died down a bit because it's at a certain consideration stage where a lot of intellectual work has to be put to it, the emotions, etc. But I think it was quite a good debate. It showed what Ghanaians generally thought about matters like that, whether for or against the issue of rights, etc. I also think my third one will be the issue about Sosu. Not because an MP has been arrested, but because of how Ghanaians have become aware of the law and how the MP in particular was trying to push his rights, etc. And the insistence of the system. The system, I mean, the police system, IGP and co, to also ensure that they carry out their mandate. Their mandate. So I think these are interesting things.
Fantastic. Well, we'll take a short break. Don't go anywhere. A Question of Law will continue. Welcome back. Now it's time for the docket. This is the segment of the show where we deal with your issues, what you've brought to us, the challenges we have. And let's take a look at the docket for today. My brother, who is lame, was called to an institution for an interview about a month back. The institution is housed in a 15-story building, and the interview was to be conducted on the 13th floor. Prior to the interview day, he had informed the HR department about his condition, and they assured him he needed not worry since they had elevators. On the day of the interview, however, he got there and realized the elevators to the building were out of service. He called the person he had corresponded with earlier and informed them about this development. The person told him he wasn't in charge of the elevators, so he should manage and climb up the stairs. He asked if he could get any assistance, and he was told someone would come down and help. Nobody showed up 20 minutes after the call, but he did a follow-up, and there was still no response. He then decided to make the treacherous journey of climbing up the stairs by himself. He tripped and fell just when he was about to land on the 11th floor. He wasn't discovered until 30 minutes after the incident. My brother is seriously injured, and what's gotten the family livid is the fact that the institution has refused to take responsibility for the role they played in it. They are claiming they didn't ask my brother to climb up the stairs, so it's not on them. We want to escalate the issue and sue the institution. How can the law help us? Well, gentlemen.
Interesting.
Yes.
I will read Article 15. Specifically Article 15(2)(b) of the Constitution says the dignity of all persons shall be inviolable. And it says no person too shall, whether or not he be arrested, restricted, or detained, be subjected to any condition that detracts or is likely to detract from his dignity and worth as a human being. So Article 15, dignity of all persons. Disabled persons, they're supposed to be accorded a certain level of dignity. If you look at the Disability Act, read together with the building regulations, they're supposed to be access points for persons with disability. Specifically, if you look at Section 6 of the Disability Act, it will say that there's a duty placed on persons who control buildings and certain public places to make or put provisions in place to ensure that persons with disability are able to have access to their facilities. Now, failure to do that is a crime. So that you will either be convicted and be slapped with a fine of not more than 50 penalty units or imprisonment for not more than 3 months. So listening to the story, I mean, there are different parts. His right to employment, his right to be treated with dignity, the fact that building regulations have not been respected, where the building regulations require that you put in structures to ensure that persons with disability are able to have access to your building. And the fact that he even made known to you before. Ahead of time. So there are a number of levels within employment rights, general fundamental human rights of the Constitution, his right as a person living with disability. And also, we can actually even look at other areas of the law with regards to failure to respect building regulations and all that. So there are areas we can look at to advise. But obviously, there will be a cause of action listening to the story that if it's a person living with disability, then your building was not compliant. His entry now led to an injury. If it was a person fit then we'll say that because the elevator was not working and you decided to climb the staircase and you fell, we'll throw in the principle of voluntary non-fit injuria. When you,
which means what?
When you voluntarily put yourself in a condition, in a situation of harm, and harm occurs, you cannot be heard to be shouting. So voluntary non-fit injuria would have come into. But now this is a special case of a person living with disability. So yes, he might have a cause of action, but then he needs to seek the advice of a lawyer.
Yeah, so I think so too, that you might have a cause of action. This person typically, I think, is an invitee. So there are invitees, there are licensees, etc. An invitee is somebody who gets into a premises or into a property for the reasons of conducting business. And I'm sure this was not a personal visit. It's a business visit, official visit of a kind. So and they knew that he was coming, and so provision should have been made for it. Section 6 of the Disability Act, Act 715, is clear. The owner or occupier of a place to which the public has access shall provide appropriate facilities that make the place accessible to and available for use by a person with disability. So the question is, did they do this or did they not? The texter says that he informed them earlier that this was his condition, and they assured him. All right, so the building, it's a 15th floor building.
15th floor
and
building.
I don't know. So I'm looking at
happening on the 13th floor.
Yes, I'm looking at a situation where they only occupy the 13th floor.
Yes, possibly.
They do not occupy everything. That is, the building is not theirs. So the question is, given that they only occupy the 13th floor, how can they take responsibility for the sport lift for everybody? That would be interesting. Or should it be the owner of the building, or because the law says occupier?
But if the person is an invitee and you've asked them to come onto your 13th floor,
but he was told
how
also,
do they have access to 13th floor?
Yes, but he was told also to wait, and that they were making efforts to come get him.
He waited.
He waited for 20 minutes.
He said he waited for.
How are they going to get him? Carry him?
No, nobody knows.
That's where the point of the dignity and sometimes how we treat these persons is actually how are you going to get him off the flight of?
So I'm just trying to bring out the nuances that may come up in this. So, they said they were coming to get him. We don't know whether at the time they said they were coming to, or they were making arrangements to get him, there was somebody actually working on the lift who has said he will finish anytime soon. But the point is, did you communicate that to him as part of the dignity? Where was he? Did you get him a good place to sit, to wait as that happened?
He got injured 30 minutes before he was...
anybody found him.
So even look at the time he had to wait. The injury occurred for about 30 minutes. So it means that, And sometimes, Kweku, in such buildings, what will happen is that the interview is now moved to the ground floor. Because someone has made a request that he is unable, or the person has issues with height. So accommodation is made for such a person. So
that is a question of dignity. So maybe you could make a special case for him. Maybe finish the other ones, but in his case, make a special case for him.
You can
reschedule it. So of course, he has a cause of action, and he has to just put his case together properly with the help of a lawyer and get vindication of his rights.
Fantastic. Well, that's good. Let's take a look at our legal trivia for today.
Legal trivia. Do you know that the Minister of Health may, by executive instrument, generally or with reference to a particular district, area or place, or with respect to a particular class or classes of persons, order the persons to whom the instrument applies who do not produce satisfactory evidence of successful vaccination to be vaccinated by a public vaccinator unless, in the opinion of the public vaccinator, the vaccination would be injurious to health? This can be found in Section 22(1) of the Public Act 2012, Act 851. Take note and do the needful. That will be all for our legal trivia today.
Thank you once again for watching yet another episode of A Question of Law. A big thank you to my guests, Clement Kojo Akapam, who is a senior law lecturer at the Faculty of Law at GIMPA, as well as a private legal practitioner, and Salam Adonu, who is also a private legal practitioner. Thank you for watching, and thank you for sending in your messages. A Question of Law will come on your screens again soon. Don't go anywhere. Keep watching City TV.